Top 5 rules to avoid being defrauded when leasing or purchasing a vehicle. The number 1 rule is to read what you sign. Now, I know this is a very basic and simple rule. However, I can't tell you how many of my clients fail to follow this rule. When purchasing a vehicle, one must realize that the dealership, although they might be nice to you, the salespeople and representatives might be genuine, and they might help you, and they might provide you the car of your choice. One must remember and realize that they're in the business of selling vehicles, which means they will say or do anything to induce the sale. That includes failing to disclose certain facts about the vehicle. If they know that the vehicle was involved in a prior accident, has frame damage, had a mileage rollback, or a myriad of other problems, the odds are that they will be inclined to fail to disclose to you this information in order to induce the sale. Now, there are honest dealerships out there. However, in my experience, the majority of transactions involve some kind of misrepresentations. That's the unfortunate reality of it. So in order to protect yourself, what you must do is read every document. Now, when you fail to read the documents, the repercussions are severe. Let me give you an example of something that might transpire. A dealership might obtain a vehicle, they'll inspect the vehicle, they'll check the history of the vehicle, and let's say they discover that the vehicle has frame damage. Well, they might proceed to retail this vehicle, never referencing the fact that the vehicle has frame damage. You end up coming to the dealership, you like the vehicle, you meet with the salespeople, they give you several reassurances, one of which is that the vehicle has never been in an accident. That being a priority of yours, you decide to purchase that particular vehicle. Now, at that point, the dealership's personnel know that if they disclose to you that the vehicle has frame damage, you will likely not proceed with the purchase. However, they also know the fact that if you later discover that this vehicle has frame damage, you have the legal right to come back and demand for a refund. You have the legal right to retain an attorney just like myself and demand for a refund. Therefore, a lot of times what they opt to do is to print a disclosure. When you go to the finance room and it's time to sign those 10 or 15 documents, one of those documents is the vehicle history disclosure form. On that disclosure form, they will write out, this vehicle has frame damage and was previously involved in an accident. Well, if you don't read all the documents, you will sign that document. If you sign that document, 6 months later, a year or two later, when you discover that the vehicle had frame damage, you'll contact me, we'll start the case, but at some point we'll find out that you signed a disclosure. That will significantly hurt your case. So the number 1 rule is to read everything you sign. Now, the number 2 rule, which is equally important, is to get a copy of every document you sign. Now, I say this is equally important because if you sign a document, you read it and you sign it, and the document looks good, there's nothing negative about the vehicle. If you do not obtain a copy of that document, the odds are, if the dealership knows that that vehicle, the one you're purchasing, has issues in its history, it was a prior accident or a prior rental vehicle, or was previously involved in an accident, well, now they have a document from you of which you do not have a copy, and most documents have a lot of blank spaces on them. They can easily add a line along the lines of the following. Client has been advised of the full history of this vehicle, including the fact that it was involved in a prior accident and sustained frame damage. Notwithstanding this history and condition of the vehicle, client willingly and knowingly is proceeding with this purchase. Now, if you don't have a copy of this document the way it was when you signed it, in other words, without that disclosure on it, it's very easy for the dealership to add that line. Once they do, once again, your case is significantly diminished, if not destroyed, because that document will stand up in court, and we will have no means of proving that the one that you signed did not have that line on it. Now, there's some variation, so I don't want to discourage anybody from contacting us should you be in a position like this. However, the rule number 2, when you're buying a car, you make sure you get a copy of every document. Now let me go into some more detail. A lot of times the finance manager who's going through the signing procedure will tell you, these are the important documents, I'll give you copies, and these are the unimportant documents. These go to the DMV, these go to the bank. You don't need copies of this document. Trust me when I tell you, you need copies of every document that you sign. I'll tell you more. If there are 2 sets, in other words, if there's one DMV title transfer form, which they intend to keep for their records, and then you're signing a second original, I want you to get a copy of both those documents. Don't just get a copy of one, because again, the second one could be used to say that there was a mistake, one was signed without a disclosure, and then a minute later we threw away that one and we had you sign another one which has the disclosure. Therefore, it's important to get a copy of every document, including duplicates and including the so-called unimportant documents. There is nothing unimportant. If you're signing it, then it's important, and if it's important, then you must get a copy of it.